Are we doing all right, Hannah? Are we ready to continue, Hannah?
Karen's just on the phone to Mr. Sissons, ready to put him through to the committee.
Thank you very much. So, members, we're ready to continue. Thank you. I seem to keep getting a repeat of what you say, Hannah, for some reason. Members, apologies for the technical problems there, and apologies to our speakers and anyone who's listening on YouTube. Hopefully, we're back in action, and we should have Mr. Duncan Sissons on the telephone very shortly. How are we doing? Is it causing problems?
Yeah, sorry, members. We are just waiting for the YouTube link to be back up and working. Sorry.
Okay, we'll be a few minutes then. Thank you, members.
Hi, Chair. We're ready to go again. We're just going to put Duncan through now. Thank you.
Thank you very much. Thank you, members, for your patience. Thank you to members of the public. We apologise for the technical error there. We're now still on item 6, so this is the 106 agreement in relation to Mickleden Edge, and our next speaker should be Mr. Duncan Sissons by telephone call.
Okay, it's through.
Hello, Mr. Sissons. You are now through to the live meeting of Planning Committee. Can you introduce yourself and say if you are for or against this item, please, just so we can check members can hear you?
My name is Duncan Sissons, and I'm speaking against the motion.
Thank you very much. Thank you, Chair, for confirmation that you can hear him. So you will have 3 minutes to speak. When your time starts, you'll hear this noise. Can you hear it?
Just about, yes.
Yeah, and you will hear the same when you've got 10 seconds left. So just so
Okay.
you know that members are listening, but their microphones are muted, so you won't be able to hear them. Is that all right for you?
Yes.
Thank you. Your 3 minutes will start now.
Thank you very much for the opportunity to speak. I make the following points as a regular walker in the area and as a chartered surveyor currently advising NHS trusts in planning and Section 106 matters. The report fails to mention that the materials used in the creation of the track are, according to the manufacturer's written instructions, for temporary tracks only. The green plastic is already breaking up and being scattered across the moor, posing a risk to wildlife. Since originally constructed, the track has been extended further towards Outer Edge using log rafts, further impacting upon the visual aspect of this wild and remote area. The track does not extend fully down to the shooting cabin at Sugden Clough or all the way to the grouse feeders below Outer Edge. The landowner is using wheeled vehicles across the triple SI at both ends, causing further erosion. The latest edition of the 1 to 25,000 OS mapping now shows 3 tracks, SK204980, which the landowner has created to access the maid track. The same is true at the Outer Edge end and in the vicinity of SK196976. These are all as a consequence of the illegal track in question. No tracks were shown on previous mapping. The material used is slippery to foot traffic, even when covered with grass. I have slipped on it and know others have done the same. The local mountain rescue team and air ambulance have been called to a walker on the 19th of November 2019 in the vicinity of SK195976, who had slipped on the track due to material used and broken their ankle. The metal hooks used are a significant trip hazard. The landowner owes a common duty of care to anyone using this land. I could cite a number of other reasons, but I'm trying to be succinct. Whilst I have no objection to a Section 106 agreement, it needs to be time-bound, bearing in mind the materials used and the fact it is causing damage to the triple SI at each end, as it does not have a logical start and finish point. There needs to be clear agreed action at its conclusion. Otherwise, all we are doing is prolonging the illegal activity. I would suggest the officer bring back the final version of the Section 106 agreement for ratification by this committee prior to it being signed. Please note the landowners have a history of illegal activity in the area, namely the failure to remove the demolition and construction materials used in the construction of the new shooting cabin at Sugden Clough, which instead of being removed to a legal waste receiver as required by law, have been dumped in the historic feature at SK 206984. Thank you very much.
Thank you, Mr. Sissons, for your call. We heard that loud and clear. Thank you. Our next speaker, or next statement to be read out, is from Henry Folkard. So when you're ready at Alden House, thank you.
Thank you, Chair. So this is a statement from Henry Focard on behalf of the British Mountaineering Council. After comprehensive consultation with its own members, the British Mountaineering Council fully supports the Peak District National Park Authority in refusing the retrospective application MP-S-1217-1304 for the creation of a surface track on land at Mickleton Edge, Midhope Moor, Bradfield in June 2018. Put simply, our position was constituted an unauthorised and therefore illegal development with clear adverse landscape impact within the natural zone, and also in a triple SI, SAC and SPA. We also noted that where some vegetation had grown through the matting that formed the surface track, grasses predominated rather than characteristic ericaceous communities. Our position now is precisely the same as it was then. The intrusion of the track compromises the essential character of a special landscape which underpin the logic for its inclusion within the national park. It has to go. For people who care about the national park, its conservation and enjoyment of its special qualities, this is a touchstone issue. Our recall is that besides our own membership, which at the time was some 80,000, 180 members of the public wrote in spontaneously to register their strong objections. We note that whilst the paper relating to item 6 of the Planning Committee agenda, the 30th of October 2020, refers to public interest in this matter, it does not refresh your members' awareness of this very significant groundswell of public concern. We believe this to be as relevant now as it was then. That said, it is evident from the above paper that officers have been diligent in their negotiations with the appellant over the proposed Section 106 agreement in ensuring that the unanimous decision by members in 2018 is not compromised. This we applaud. To this end, we believe it is imperative that, as the recommendation at 4.1 states, the clause relating to the authority's power to decline to determine a future application must be omitted. Explanation of the logic for a 28-month extension to be revised period for compliance is not apparent to us. Why 28 months specifically? What purpose does that figure serve beyond extending the presence of the surface track? We are uneasy that withdrawal of the appeal would in fact guarantee greater certainty of outcome. On our reading of the paper, it seems clear that officers have been at pains to ensure that this is indeed the case, but we should make clear our concern that a 28-month extension could achieve little more than leaving the track where it is for a longer period, and that after that time, some other as yet undisclosed stratagem to allow its retention even beyond that period would be deployed. We are not party to all detail in the case and accept that ultimately it is for authority members to balance all the considerations and make their decision. We would urge that in doing so they adhere to the twin statutory purposes which underpin the very existence of national parks in this country. For us, this issue goes to the very core of why we have national parks and want to retain them. This principle cannot be compromised. As I said at the outset, our position is unequivocal. This is an illegal and unauthorised development and cannot be allowed to remain.
Thank you, Hannah. Our final offering on this section is from Mr. Berzins, and again, the statement to be read out by Democratic Services.
This is a statement by Bob Berzins, Local Access Forum Vice Chair. I am writing on behalf of the Peak District Local Access Forum to comment on the enforcement action against the creation of a surface track at Midhope Moor. The LAF supports the recommendation, Section 4. 4.1, that the offer of a Section 106 obligation in respect of the appeal relating to the creation of a track, Midhope Moor Langsett, be accepted, subject to the omission of the clause requiring the authority to use power to decline to determine a future application. And the LAF also supports the suggestion for determination of wording. 4.2. The detailed wording of the Section 106 obligation to be delegated to the Director of Conservation and Planning in consultation with the Head of Development Management and the Head of Law. But we ask you to consider the following points. 1. We agree the authority must require the omission of the clause requiring the authority to waive its power to decline to determine a future application. We feel this is essential so the final outcome of the track being completely removed and the area restored is not compromised. 2. The final outcome for the track removal must ensure the special qualities and landscape of this area are not damaged. 3. The track was constructed at the behest of Natural England at a cost to the taxpayer of £20,529. This money will have been completely wasted when the track is finally removed. The public has put its trust in the authority to resolve this sorry situation with a minimum of further costs. 4. We ask the authority to make a realistic judgment of how trustworthy the estate may be in any agreement. The Section 106 agreement would need to specify exactly what actions are expected within a given timescale, and if not fulfilled, what action the authority can easily pursue to ensure compliance. How could 50 days use per year be monitored, and doesn't this imply the estate would simply do nothing for an extended period of time before starting any removal and restoration? 5. The current servicing of the track is posing a danger to the public. Woodhead Mountain Rescue has dealt with one injury to a walker who tripped on one of the pegs used to fasten the plastic matting. The walker had to be evacuated from the site by air ambulance. I have slipped on the plastic matting and companions have slipped on the logged sections. Walkers expect and anticipate natural hazards, but the slippiness of logs and plastic are completely unexpected and dangerous. Therefore, these materials need to be removed as soon as possible. Thank you for consideration of our comments.
So thank you, Mr. Berzin, for his comments there, and thank you also to Democratic Services for supporting those comments. So now I'll hand over to members for questions and comments, bearing in mind that this is looking at an SO6 agreement. It's not actually looking at the track itself. So how do you feel about the S106 agreement? Thank you. Patrick, I'll start with you. Thank you.
Thank you, Chairman. As somebody who's had quite a lot of experience of this sort of thing in the past, this kind of approach is perfectly sensible. And I certainly didn't, reading the report, find myself troubling too much about what it was saying. However, as John was making his presentation, there was an issue that occurred to me, which was something that was raised by one or two of the speakers, which is the state of what's there now. Having looked at the photographs that we've been shown, and heard what one or two people have been saying, it's the deterioration factor and the damage that will be done by it deteriorating further and scattering all over a very valued area of moor. And I'm wondering, I'm wondering whether it's right to extend a timetable given the state of deterioration that we're beginning to see there. I wonder whether I could have a comment on that.
Yes, thank you. It's an interesting point, Patrick, because, yeah, as you saw on the photographs, the bits which aren't performing well are becoming increasingly worse. And we're getting a lot of plastic litter, as I think one of the speakers said, in the SSISCSPA in a national park, at the highest designations you can have, really. I think the difficulty, from a legal perspective, if I can describe it that way, is what we are able to do whilst the appeal's running and whilst the enforcement notice, assuming we win the appeal, whilst the period for compliance for the notice is still in place. And in that situation, we can't do anything about it other than require full compliance with the steps. Obviously, the difficulty with what we've got at the moment is that we are being asked to accept the track for some time longer. As I explained earlier, it's hard to compare the two because the start dates aren't the same. What I do think is that if we're dealing with somebody where we have a Section 106 agreement and we're trying to work towards an agreed end, which is removal of the track and the restoration of the area, I think we have a much better chance of engaging with them early to say, look, this stuff's a mess, and in the places where it's not performing, show some good faith and start to remove the bits which aren't working well. Now, how we do that in a legal agreement, I'm really not quite sure at the moment, but we're much more likely to be able to work with them showing some good faith through a legal agreement, as opposed to having to prosecute the enforcement notice. So I think you're right. We try and pick that up with them. Whether we can tie it up legally in the agreement, I just don't know at the moment, but that's something we can look at. Thank you.
Thanks, John. Patrick, yes.
Follow on from that. I mean, I think that's a sensible approach as far as it can be done. There are a lot of pitfalls in this, not least the fact you're dealing with a limited company, and a limited company can go out of existence very quickly, and I hope that will be taken on board. But recognising the practicalities of what you've got here, I think this report is, on the whole, common sense. And I'm happy to move the recommendation of the report.
Thank you, Patrick. Mike Chaplin.
Thank you, Chair. I should have spotted it earlier. I have met Bob Berzins previously and been on a walk with him. So I have a personal interest there, and I had a conversation with him about this path about 15 months ago, before this report came to us. So I'm declaring a personal interest on that. And I also know a person called Simon Rippon, but whether it's the same Simon Rippon, I've no idea.
All right, thank you, Mike.
But I had no predetermined view on this until so I'm approaching this with an open mind.
Thank you very much. Right, Ken Richardson.
Thank you, Chair. Obviously, I weren't around when this was determined before, but I consider this agreement a frustration of the will of the committee. It should pursue the appeal, hopefully win it, and get it done, because reading through the back papers, this company, I understand it's a company, has a history of not obeying the laws and do's and demands. So I don't think what's going to happen is a 6 years unauthorised use of this track, what appears to be feeding gun shooting positions, which will continue. So it's a money-making job, and I should think it should be pursued to the end of the law. Thank you.
I wonder if I could just maybe comment on that, Chair. I think it's important to recognise that, as with a lot of moorland tracks, it's used for more than one purpose. Obviously, the moor is a shot moor. Whether they use this track, I don't know. But the track was installed, as you've heard from other speakers, actually. It was done with the agreement, and it was partly paid for by Natural England in order to achieve some conservation work. So I think it's important that we don't simply characterise this as a track for shooters. It's important we don't do that. Picking up on that, the first point you made there, Ken, because it's a point I think some of the speakers made. This is not capitulating. If you think about what we're trying to achieve here, we want to win this appeal so the enforcement notice comes into place. What we're being offered is the enforcement notice coming into place because the appeal's been withdrawn. So this isn't a question of officers not having, not following things through, not having any tenacity. One of the words that was used by I think two of the speakers. We're trying to achieve the right thing for the authority here, and this gives us greater certainty we're going to get it. So it's important to bear that in mind. This isn't us withdrawing the notice, because that would be capitulation. It's a question of us achieving what we want, but on certain conditions, I suppose, is the best way to describe it. Thank you.
If I can come back on that, Chair.
Yes, Ken. Yeah.
Yeah, thanks for that, John. I understand what you're saying, but this chap gets another 2-year use, and we don't get many grouse in middle of Barnsley, but I would imagine the 50 days is the grouse shooting season. So he's got 2 more years of a commercial activity at our cost, as it were.
I think it's important to recognise that one of the things that we've asked the appellant for clarification for as time has gone by has been clarification as to their desire for that track either to remain permanently through the appeal or on a temporary basis. And we've asked for clarification about conservation works because that's been part of their argument all along, really. And initially it did go in order to achieve conservation works, and conservation works have been carried out. We have asked for clarification about its continued use, and we've had the idea that they want to retain it for conservation works, and we've asked for clarification from both Natural England and from the appellant about what those conservation works might be. We're awaiting a reply on that. And so, given the position we're in at the moment, I think it's really important that we don't make assumptions, although it might well be used in association with a commercial activity. You're not wrong, Ken, but it's important that we don't characterise it as being just for that purpose, because we have no certainty that that is the case.
Well, I just picked that up from reading through the past notes that the shooting butts, what they call, and they ain't got planning permission either. This is in the papers from the previous determination. So I've picked that up. I don't know nothing about it. I've never been on board. I fly through it on my motorbike, you know. Thank you.
Right, thank you, Ken. Can I go to Ken Smith then, please?
Thanks, Chair. Just a couple of questions for information, really. Progress this. Do we have any intelligence as to what the purpose of the proposed clause that we cannot agree to actually is? Though I accept that that might be speculative. And have we had any feedback from the appellant against the recommendations that are being proposed?
That's a good question. I can answer those. Thank you, Ken. Yeah, I've asked this week what the appellant's position is on the recommendation. We sent them the paper last week, and I spoke to them the previous week to say this is what the recommendation is likely to be. And I had an answer which was essentially, we'll see what the committee makes of the recommendation. I take that as their response is that if you endorse the recommendation that's in front of you, which is to accept the obligation, but without that clause, they will have to take a view on it then, because essentially what we're asking you to agree here is an alternative offer. It's a counter offer. When I chased them yesterday to say, have you got a definitive response on that, on the removal of that clause, they said have been seeking legal advice. I assume the fact I've not had anything back from them means they haven't got their legal advice. It leaves us in a position where we should have a view on this and understand whether or not we're prepared to make the counter offer, which is the obligation without that clause in it, with the detailing of the other bits being left to officers to fine tune. What was the first question, Ken? Sorry.
It was about what the benefit of the clause that we can't agree to is.
That was it. Yes, of course. Yeah, and I think it has to be that they want to have an option at some future days. I'm speculating here, but it's something we've discussed as officers quite a lot between ourselves. The only purpose of that being in there and asking us to waive our right to refuse to entertain an application can only be so that at some future date they're able to make a planning application, and we're obliged to we'll be obliged to determine it. And
John, can I just come in there?
Sure, please do, Jane. Yeah, it's something we've discussed, isn't it? Yeah, thank you.
It is, and I think actually rather than spending a lot of time speculating about somebody else's motivations, I think we need to think about the end result for us. And if we, my concern in the discussions we've had, I think it's fair to say, John, has been that the clause as it's set out in terms of fettering us in our ability to decide not to consider a planning application in future may result in a situation where we get to the end of that period of time and an application is made and then appealed against, and it could delay the period of time that the appeal could exist. Now, we could still enforce the enforcement notice, but I think it presents a degree of uncertainty at that point, and I think it could fetter us in terms of our success in that regard. And so the Section 106 terms as put forward, and as we've set out in the recommendation 4 that we would agree to, give us real certainty. The notice comes into effect and achieves what we want to achieve, as long as that clause isn't included, because that clause introduces uncertainty. So I think the recommendation is correct, obviously. But I think that clause just introduces a degree of uncertainty of outcome. And also, we don't know in 28 months' time what the situation might be. I think we all know anything can happen, particularly these days. And to make a decision now to stop us taking a course of action in more, several years' time, we don't know what situation we'll find ourselves in then. So we can't make a decision ahead of time, in my view.
Yeah, and I think really briefly, if I could add to that, I think what you said is really important, Jane. After you, Ken, sorry.
Ken, do you want to come back on that?
No, it's okay, John. Yeah, it was just to thank Jane for the clarification.
So, John, can I just add something? You said that the appellant was seeking legal advice. So I presume we've sought legal advice, and I think that without that that clause, we're on the right side, basically.
Yeah, I'll let Reg speak if he wants to, but there's two questions here. One, is it something we can do legally? And secondly, if we could do it legally, should we on its merits? I think something Jane has just said, and apologies for talking over you there, Ken. I think the certainty that's on the table now is actually undermined by the uncertainty which would have somewhere down the line if we have that clause in. Because that clause can only be there for one purpose. It's to give the appellant the opportunity to make an application in the future and make the case again. So the certainty that's on the table now would be undermined by that future uncertainty. Legally, and you may want to add to this, Reg, we think it would be the wrong thing to do as well, or we shouldn't do it because it would fetter our discretion. That's the phrase I think you've used, Reg. In fact, do you want to explain that, Reg? I'll leave that to you.
Yeah, my view is that you shouldn't accept it. The reason is this is a discretion which can be exercised when someone makes a future planning application and there's an enforcement notice in place. It is a sort of discretion. It's a relatively new power, but there are a couple of cases on it. It's a discretion, and it's of a type, as indeed things like decisions of the planning committee, where because of the future unknown circumstances, you can't make a decision now, and the courts treat these attempts or clauses in agreements, various ways in which they attempt to stop you exercising that future discretion. They treat those as invalid, and I think this clause, not the whole agreement, but this clause would be invalid. So it will be misleading to leave it in there, even if it's not subject to a challenge by anybody. It will just mislead the future decision-making process that somehow it is valid. So I would strongly endorse leaving it out for those reasons.
Thank you, Reg. Can I go back to Ken? Sorry, Ken, yeah. we sort of cut you off earlier on.
No, the internet broke down again. I mean, I was going to, in a sense, going to apologise for having introduced something of a red herring because, as Reg has already said, I mean, the legal advice is that we can't really accept this clause anyway. So my apologies for that. But what I was going to go on to say was that there has been some play on the timetable of things to date and things that could or might occur in the future. I think we need to bear in mind that for no reason, for no fault of our own, it's been delayed by 2 years by the planning inspectorate. We've been waiting for this December hearing to be approved. But I think the point is that it's endorsing what John and Jane have been saying about if we approve this now, and I'm minded to support it and to second moving of the recommendation, then the clock starts ticking. And I think that's quite important. But even so, there's uncertainty over agreement of it. The appellant might not agree to the agreement if we withdraw this, delete this clause. That's something that we have to risk. But then there is the fallback of the appeal in December. So we do have a fallback position. But even if we have to fall appeal, there's no guarantee that we're going to win. If we do win, if we're being positive about it, we might hear, as John has said, in the first quarter of next year, but because of the bird breeding season, works wouldn't be able to take place until the autumn of 21. If there's a delay because of the pandemic or whatever else, we can't be sure about any of these things. We could find ourselves in October 22. You know, we're still, there is a big degree of uncertainty. The other thing is, if we approve this, the recommendation is that at least the clock would start ticking and we would be able to progress it at last after all the delays that have occurred. So on that basis, I will second Patrick's moving of the recommendation, Chair.
Thank you, Ken. Any further comments or questions from members? I can't see any hands going up anywhere. We have a motion which has been proposed and seconded to accept the recommendation. So I will hand over to Hannah at Alden House for the vote. I see Andrew Gregory has joined us, but unfortunately, Andrew, you can't vote on this. David Chapman has left us, and I'm not sure where Kath's gone, but we'll find out in a minute. So over to Hannah, thank you.
Thank you, Chair. Members, if you could just let me know if you're voting for, against or abstaining from this recommendation. Thank you. Councillor Armitage.
For.
Councillor Brady.
For.
Councillor Chaplin.
For.
Miss Harlan.
For.
Mr. Helliwell.
For.
Councillor Mrs. Potter. I think she's left us, Chair. Councillor Richardson.
Against.
Miss Slack.
For.
And Mr. Smith.
For.
That is carried, Chair, with 7 for and 1 against. Thank you.
Thank you very much, Hannah. Thank you very much, members, on that one. And thank you for your patience as well. We move on now to item 7, and this is, item 7. Move on. Excuse my paperwork. Sorry, item 7, monitoring and enforcement, and it's the annual review, and it's Andrew Cook's going to take us through this. So welcome to Andrew. Are you with us, Andrew?
Yes, I'm here. Can you hear me?
Yeah, fine, thank you.
I don't think you can see me, but hopefully you can hear me. I can't get my video to work at the moment, so I'll just stick with the voice. Yeah. Good morning, or I think it's now afternoon, members. It's been a while since I've brought this report to committee, as explained in the first paragraph of the report, if you've got it there. We normally take this report to committee on a quarterly basis in April, July, October and January. But the pandemic unfortunately has put a big spanner in the works. So we didn't take a report to this committee in April or July of this year. So the last report of this type was considered at the committee in January 2020. So there is a bit of catching up to do. The report is perhaps a little bit longer than it normally is for that reason. The report is essentially split into 2 parts. The report itself is an annual review, and that takes us up to the end of March 2020. as I say, this would normally have been, the annual review would normally have been taken to committee in April. So that's the first part of the report. It sets out the activity in terms of notices issued, appeals, etc. In the last full year up to the end of March, and also summarises in paragraphs 11 to 14 the performance overall against our targets. And then the second half of the report focuses on the period since then, so from 1st of April up to the end of September this year. And that starts at paragraph 15 in the report. And then at the end of the report, there is a list of cases that have been resolved in that period since April up to the end of September. So if I just briefly take you through the report itself and just pick out some of the perhaps more important points and some of the highlights in terms of the work that we've undertaken over the last year in particular at first. The first thing to note in the introduction, most of the introduction is fairly standard wording for this report, but then in paragraphs 6 to 8, I've just included some information there about team resources. Essentially, we've been hit by what you might call a double whammy in terms of the pandemic, obviously starting to take effect in March. We also had a couple of officers who left the authority shortly after that in early April. And a previous officer had also left in January. So we have been hit by, as I say, people leaving the team, and we have found it very difficult to fill those vacancies. And the situation is set out there in those paragraphs. I won't go into detail, but essentially the position we were in previously is that we had the equivalent of 5.5 full-time staff, albeit one of those was on a temporary contract of 2 years and left after a year of the contract. The current position, or since April, early April, is that we've been down to 3 full-time equivalents. So we are 2.5 team members down. Now, naturally, that will have an impact on our performance, has had an impact on our performance, particularly in the last 6 months. And I think the headline in terms of performance is that if you look at the situation up to the end of March, the year up to the end of March, when we were fully staffed, the performance was very good. We were heading in the right direction. And then since then, as you'd expect, the performance has not been so good. And that comes out in the report, and we'll touch on that in a moment. So that's the introduction. In terms of the next section, which summarises the position in the year up to the end of March. So this is looking at paragraph 9 of the report, first of all. And here you'll see that we've listed the notices that have been issued, the formal notices that were issued in that year. So we issued 11 notices. The last couple of notices that are listed in that section, we've got some photographs, and I think one of the first photograph is already up on the screen there. So this was an enforcement notice against the erection of a dwelling house at Wardlow, land south of Black Harry House. The enforcement notice was issued in February. It was due to come into effect in April, but an appeal was lodged. We have actually had the appeal decision very recently, this month, and the appeal was dismissed. So the enforcement notice has been upheld. Just briefly, in terms of the background, this was a planning approval that was granted for the erection of an affordable local need dwelling in Wardlow. The applicant has obviously built a house, but unfortunately the house that's been built is not in accordance with the plans that were submitted and that were approved. It's not in the right place. It's slightly further back in the site than it should be. The dimensions of the house aren't as approved. If we could just move on to the next slide, please. This is the rear of the property. The next slide, please. This indicates or illustrates one of the main issues that we had with the property, because it shows the comparison between the new property on the left and the original cottage adjoining it, which is in different ownership, just to the right. And you can see that the new dwelling is significantly higher, the roof pitch is significantly steeper, and also the gable width is wider than on the adjoining property. And all these are issues with the property as built, and were issues that were issues of non-compliance with the original plans that were approved. As well as the overall form of the property being an issue, that also poses problems in terms of the restriction to affordable local need, because obviously there are size limits in terms of floor space for properties to be retained as affordable dwellings, and the increase in size of the property created a compromise in terms of compliance with that policy aim. So, as I say, the enforcement notice was issued. We've recently had an appeal decision that was in our favour, and the enforcement notice is now due to be complied with. The next photograph or photographs are of the next site, which is land at 1 Acre Wood in Little Hayfield. Again, this is construction of a dwelling, but obviously a very different type of dwelling. And in this case, there is no planning permission in place at all. So this is a small area of woodland to the north of Little Hayfield, between Little Hayfield and Glossop. The owner of the woodland lives down in Hayfield, and he purchased this piece of woodland as a freestanding piece of land some years ago. As I say, the building is not conventional in terms of stone construction. It's obviously a timber building. But if we move on to the next photograph, this just illustrates part of the accommodation inside the building. You can see that it's got a fully fitted kitchen. There's a staircase up to a sort of mezzanine level where there's a sleeping area. So to all intents and purposes, it's kitted out inside as a dwelling. And clearly in that location, it's not something that we would normally accept. So we issued the enforcement notice in March. Again, it was due to come into effect in April, but an appeal was lodged, which puts the notice into abeyance. And the appeal decision is currently awaited. The following section of the report, there's 3 cases in paragraph 10, where we've had appeal decisions. These are appeal decisions received in the last year up to the end of March. And then the following paragraphs 11 to 14 with the table below summarise the performance in the year. So the main highlights there, or the main points to draw out, are that we had a target of resolving 120 breaches of planning control each year. And in the year in question, we resolved 140 breaches. So as I said before, we were fully staffed. We were able to meet or significantly exceed our target in that case. We also continued perform strongly on dealing with inquiries. So these are issues that first arrive into the authority and have to be investigated, potential breaches of planning control. And we have a target of 80% of those being investigated within 30 working days. And our performance over the last year was 84%. So again, we exceeded the target in that case. The figures below in the table just summarise the number of inquiries received, investigated, and number outstanding at the end of the year. And then also the same in relation to breaches of planning control on the second line of the table. There is a correction in the table actually in the in the inquiries received. Your report states 491 inquiries received compared to 400 in the previous year. The figures should actually be 480 received compared to 491 in the previous year. So the 491 figure is from 2018-19. So then we move on to the second section of the report, which sets out the performance and summary of our activities since April. So again, the first part of the report there is 3 cases where we've issued formal notices. And again, we've got some photographs relating to these. So the first one is Brackenburn at Riddings Lane, Kerber. This was planning permission that was granted for erection of a replacement dwelling. And you can just see on the photograph the roof of the dwelling, the replacement dwelling and the chimneys. The issues here were non-compliance with conditions on the planning permission in terms of the erection of the gates that you can see in the photograph. And also, if we move on to the next photograph, so this is the replacement dwelling. The other issue is the colour of the windows, the colour of the frame finish on the windows. There was a condition requiring details of that to be submitted and approved, and we would have expected to agree either white or an off-white colour for the window frames. They didn't comply with the condition, they just went ahead and stained the window frames dark brown, as you can see. So we issued an enforcement notice in relation to those 2 issues. An appeal was lodged, and again we've fairly recently had the appeal decision, and the appeal was found again in our favour. So the inspector supported the authority's position in terms of the gate posts and the gates, which we felt were out of keeping with both the property and the immediate setting, and also the colour of the window frames. So again, that the enforcement notice has been upheld on appeal, and the time is running for that to be complied with. The next enforcement notice, if we can move on to the next slide, please. So this is land at the former Whitelow Mines on Bonsall Moor, or near Bonsall Moor, and it relates to use of the land for motocross scrambling. The photograph's obviously taken from quite some distance away, but it is quite useful in that it shows the setting of the site, obviously in very open and attractive countryside generally. And you can see, hopefully see in the photograph, that there are a number of vehicles parked on the site. So this photograph was taken when the site was, when the activities were underway. The land in question has been used for motorcycle activities on and off for many years. The issue is really that there's been a relatively recent change in ownership and operation of the site, and the use of the site appears to have intensified quite significantly to the point where we consider that there has been a change of use. There's also been some physical works taking place to the site as a result of the change in ownership. So the enforcement notice in this case, there was a lot of public interest in this in regard to local residents suffering problems with noise disturbance, issues with traffic using the narrow lanes in the local area, etc. So there has been a lot of local interest in this. We issued an enforcement notice in June. It was due to come into effect in August, but an appeal has been lodged, and the appeal process is currently underway. So finally, in terms of notices served since April, this is Home Farm at Sheldon. Now, some of the members that have been with the authority for some years may recall issues at this property previously. There have been quite a lot of enforcement issues related to this property over the last probably 20-25 years, on and off, all related to the same owner who's had the property all that time. This particular issue relates to the building works that you can see quite obviously in the photograph. The building, the main building sort of to the left of the photograph is the former dwelling, which is now used as a guest house and has been for some years. That was with planning permission, the guest house use. This is at the rear of the property, where the owner has fairly recently carried out quite a lot of excavations, and obviously you can see he's constructed some block walling, etc., and put a concrete base in the bottom of this excavation. Quite substantial building works. So in response to that, we issued a temporary stop notice, which comes into effect immediately. So it was issued on the 25th of September. Temporary stop notices only last for 28 days, but they are, as I say, they do have immediate effect. If the work had carried on in breach of the temporary stop notice, then it would have been an offence that we could have prosecuted, or we could have taken an injunction, etc. Happily, the temporary stop notice did have the desired effect, and the work was put on hold. As I say, the temporary stop notice ceased to have effect on the 23rd of October, so last Friday. We have now issued a full stop notice, which basically continues the effect of the temporary stop notice, and also an enforcement notice, which requires the walls, the building works to be removed, and the excavations to be reinstated. That was only issued on the 6th. They were issued on the 16th of October, so we've not had any sort of formal response from the owner yet. We do understand, though, that the work is still on hold as we speak. Okay, so the next, we've got, well, one in paragraph 16. There's one appeal that's been determined since the 1st of April, which is land at Bottlecroft, Chelmorton. In that case, again, the appeal was dismissed. We've had some really good results on appeals over the last year and a half. In that case, we're talking about a temporary dwelling that was erected in connection with the erection of a new house on the same site. And the erection of the new house is taking many, many years. The owner is carrying out the work himself, as we understand it. And as I say, it's a very slow job. So the house is more or less finished, the shell is up. But all this time that he's been building the house, he's had this temporary dwelling on the site, which was initially given permission to be there for 2 years. It's been there much longer, so we've served an enforcement notice to remove that temporary dwelling, and he's now got 6 months to do that, ending on the 23rd of January. Paragraph 17 to 19 summarise the performance over the last 6 months. As I say, because of the challenges that we've faced, we haven't performed as well as we would have liked to. We also, because we had performed particularly well in the previous year, we actually increased our target at the start of this year for resolving breaches from 120 to 150. Now, in hindsight, that seems like a bad decision to make. But obviously at the time we weren't aware what was just around the corner. But in terms of performance on that target, we have resolved 40 breaches in the last 6 months. Obviously, if you double 40, we get to 80. So we're, at the moment, there's a very high risk that we will not meet our target at the end of the year. We're certainly some way off, likely to meet the target of 150 at least. Our performance in paragraph 18, our performance on inquiries has actually held up really well in the last 6 months. As you can imagine, our job depends a lot on getting out on site to investigate issues. And with the first part of lockdown, for probably 2 or 3 months, we couldn't do any site visits at all. And then since then, we have been able to do some site visits, but we're still obviously limited in terms of particularly visits to domestic properties or other occupied buildings. But despite that, we have still performed well, as I say, in relation to our target. So we have investigated 77% of inquiries within 30 working days against a target of 80%. And the table below again summarises the figures for the last 6 months. Just briefly, the remaining part of the report, as I said, lists the cases, the 40 cases where we've resolved breaches in the last 6 months since the 1st of April. We have got a photograph up there of one of the cases, and I've also got a couple of photographs of one other case just to briefly show you. I've picked these out because I think they are quite striking in terms of the before and after position. The other thing is that in both cases, the resolution of the issue was brought about eventually by service of enforcement notices. So this first site that you can see is the former Backdale Quarry on Hassop Road near Hassop. And the issue was the use of the quarry for the storage of reclaimed building materials. There was also a haulage business taking place. So you can see there the photograph looking down on the quarry from the public right-of-way or near the public right-of-way at the back of the quarry, former quarry. And then if we move on to the next photograph, you'll see that there's an obvious difference there in terms of the materials being removed. So that's been a good success for us. And then if we move on to the last couple of photographs, the next one, the final case I wanted to draw your attention to is land adjacent to the Kerber Village Hall. As I say, again, this was a site where we served an enforcement notice relating, in this case, to the storage of stone on agricultural land. The enforcement case was created in 2010, and I think the enforcement notice was issued around 2012, 2013, and we had an appeal. The enforcement notice was upheld. So it has taken quite a while to get to this point, but if you look at the next photograph, I think you'll see that perseverance was worth it. The stone has now been completely removed, and we've returned back to a nice green field. Okay, Chairman, that's me done. If there's any questions or comments.
Thank you. So any questions for Andrew? Patrick?
Yes. Thank you, Chairman. This target that is set for the year, who actually sets it?
It's set in discussion with Jane as the head of service, and it's written into our what used to be called service plans and now called delivery plans. So it's on an annual basis. We look at our targets, and as I say, it's a discussion between myself, the team, and Jane as the head of service.
So it's not a target that appears in the
KPIs.
corporate policy documents. It's something within the department.
So it's not part of the KPIs because it doesn't form part of the management plan, Patrick. It is part of the corporate plan monitoring that we do, where we set delivery plans for each individual service in the organisation. So it is part of our monitoring that we do for the corporate plan, but as you know, that's currently separate to the management plan.
Well, I'm baffled, say so, by the way the system works. And I think what you've done quite successfully here is actually pinpoint a hole in our corporate planning processes. I'm in no doubt that for a lot of members of this authority, planning enforcement is a high priority. And it's a high priority for lots of very good reasons. One of them is about landscape protection, as we've seen only too clearly in the photographs we've just had. And one of them is about reputation, because as a very prominent planning authority, and as somebody who lives in the area, by gum do you hear about it when things are not followed up and enforcement followed up and so on and so forth. And it worries me that officers are able just to cut a budget and change the priorities of the committee by saying, well, we're not going to appoint enforcement officers, when we all know this is a major priority for the authority. And I don't know where that, I mean, I get confused, I have to be honest with you, about our corporate planning processes. But I don't know where in the way in which we as an authority fix the priorities for action of one sort or another, enforcement lies, because I don't think it lies anywhere within what we as members are asked to decide. This seems to be something that's dealt with within the management rather than within the political field. That worries me, because if this had been a KPI, I don't think that budget would have been cut like that, and we would have had the same problems with enforcement. Am I wrong?
Jane?
Yeah, I mean, in many regards, Patrick, I don't disagree with you. I'm sure John Scott will be.
That, Chairman, is all I wanted to hear, because really it's got to be addressed. And, the message has to go back to the senior management, whoever's making these decisions, that we regard this as a priority and that this is a budget that can't be cut like this without proper consideration of the issues.
Yeah, I've long been concerned that the absence of planning in the KPIs related to the management plan could potentially lead to issues about resourcing and monitoring. And I understand that we are monitored by MHCLG, and that monitoring the same thing twice does potentially lead you to a position where you're sort of you're perpetually sort of flagellating if you kind of fail. And so I can see the point of that, but I also think that it means we have missed opportunities for reporting and for funding.
Chairman, sorry, if I could just interrupt Jane though. We have a KPI, for example, about landscape enhancement and protection. The enforcement service is one of the major methods by which that is achieved. And although there is neither a KPI which recognises that, nor is there a target that goes with it. And if you take the landscape the landscape KPI in the corporate plan we were discussing a week or so back, you can put a target in that for what you're trying to do with planning enforcement. And I don't see how the two miss each other. Yeah, and I think it needs to go back to the management, the clear message from the committee that we want that to be looked at.
Thank you, Patrick. Jane might want to come back on that. I see John also wants to comment on that. Jane, do you want to take that up?
Thank you. I think there are some early stage discussions about the management plan and the corporate plan and how they relate to one another and whether or not they need to be separate documents. And that's one of the things that I think we need to work towards in future. I'll hand over to John.
Yeah, thank you. In fact, I was going to mention that, Jane, because there has been... no, it's okay, because as part of the wider context, obviously with the focus on resources, in a fortnight's time, authority will be looking at that with a focus on resources and on how reduced resources. There's a question of how we work. So there has been some talk about bringing the corporate plan into the National Park Management Plan, because they're both they both demand quite a lot of attention. And I think the argument is that the corporate plan, corporate strategy is our contribution to the National Park Management Plan. In terms of service plans, I think Jane explained it really well earlier by explaining that the targets we're talking about here are within the service plan. The difference is, compared to a lot of service plans, it actually comes to a committee, which is why we're discussing it now. If you think we've got 12 services across the organisation, they each have a service plan, and they'll each have a lot of really quite detailed targets. It's not appropriate, I think, for all those to come up to full authority or up to individual planning or performance and resources committees. I think you need to see the summary of all those somehow. I think the point you're making here, Patrick, is this is really quite important, because we have a lot of targets which are relate to landscape. And if we don't get enforcement right, it can have as much impact on the landscape as all those other things you hear about elsewhere. In terms of resources, the issue, as Andrew explained earlier, the main problem we've had hasn't been resources being cut from the team. It's been vacancies which have been empty for a while. Having said that, there have been some difficulties, and Jane is bringing a paper in the next couple of weeks, actually, where we're looking at the resources in the team and how we sort out some of the vacancies we've got. So yeah, I think the point you're making, like Jane, I can't really agree with anything. Sorry, I can't really disagree with anything you said. Sorry, important word, disagree. The question is, at what level the detail gets up to members? So I think I will take that back to SLT. We have a meeting every Monday morning, and I usually report back on what's happened at committee. And as I'm on this one, I can do that directly. Thank you.
Chairman, I'd be very grateful for that. John will know what I'm saying when I say this. We have a target about the number of times this committee makes decisions which are alleged to be contrary to policy. It's a completely meaningless target. A target on enforcement, however, would be meaningful. And it's not a detail, it's absolutely fundamental. It really isn't a detail. I know there are detailed things which departments do and which shouldn't appear in big corporate policy documents. But keeping enforcement at the top of the pile and as a priority is something we need to do. And it's far more important than a lot of the other things that appear in that corporate strategy. I've said my piece. I hope the message is clear.
Thanks, Patrick. Yeah, well said. Are there any further comments on this?
Andrew, can I?
Sorry,
just
Andrew
say,
Gregory. Andrew, before you just start, can I just point out that we've got to take a vote to go past 1 o'clock, which we're unfortunately going to do. So can you just all signal your acceptance to go past 1 o'clock by sticking your hand up? Thank you. Thank you. That's carried. So Andrew, over to you now.
I just wanted to say that I found Andrew's report really interesting, really useful. And I understand entirely as well all the points Patrick's made. The only point I want to make, Robert, is that I just think Andrew and his team are doing a great job given the limited resources. And that certainly in the last 6 months, I'd just like to say thank you to him for his report and his team for carrying on doing a cracking job on enforcement. And I certainly, I get in my patch, not obviously just on Peak Park, but on Cheshire East, all sorts of issues. Got one this morning in on my emails about enforcement, and these things are really, really emotive and important. So I think, Andrew, thanks very much. You're doing a cracking job.
Thanks for that. Thanks for that comment. I'll pass that on to the team as well, because I know they've worked very hard and under very difficult circumstances, particularly over the last 6 months. Just as an aside, I noticed recently there was a headline figure about number of enforcement notices issued by authorities across the whole of England, I think it was, or possibly England and Wales. And there are actually 41 local authorities who didn't issue one notice in a whole year. So I just thought Just
And
thought I'd
including
let you into that. Let you into that
Yeah,
bit of
well, the same
information
thing.
because it's quite revealing.
Yeah, including Chesterfield, I noticed, Andrew.
Really?
Yeah.
Any further comments or questions? We are asked to note this report, so we don't have to take a noted it. Thank you. And that, I think, concludes the meeting for today. So thank you very much for your input. Thank you for your patience. And thank you to Democratic Services for your input. And we'll see you all. It's next Friday. I think we have a proper planning meeting. Yeah.
I mean, this one wasn't a proper planning meeting, Robert.
As opposed
programmed, should I say?
Pretend one.
It's just a warm up.
See you all next week.
Thank you, then.
Goodbye.
Thanks, Robert.
Jane, are you circulating? Thank you.